All right, first up, I want to talk about the quiz for a second. I got some emails about a couple of questions that were worded a little bit confusing, and I went back and read them, and there are a couple that are confusing, so I'll be kicking back some points to y'all on that. One of them was about whether or not the Brown case was in the state or the federal court system, and the answer was it was in the federal court system the whole time, but I went back and sort of read through it again, and I can understand how y'all were confused on that. So I'm going to kick back some points on that. And then if you took the quiz before 8 p.m. last night, there was another confusing question about sources of law where I said all the following are sources of law except, but then the answer was all of them. Pre 8 p.m., post 8 p.m., I had fixed it, but I'll kick back some points to y'all for that. So no worries. I do love that you ask questions about potentially confusing or wrong questions because I write those quizzes every week. I try to do them new every semester. So, I mean, I'm just writing them and they make sense to me, but that doesn't mean they make sense to you. So please do ask those type of questions. It shows me that you care and that you're interested, and it can potentially result in y'all getting some points back. So please keep doing that. We talked about the idea of jurisdiction on last Thursday, and that's really kind of part of this week's lecture. So I'm going to go over it again just briefly because we kind of covered it. But I want you to remember that jurisdiction is the power of a court to hear a case. We have personal jurisdiction. Does the court have jurisdiction over the people that are in front of it? And then we talked about subject matter jurisdiction. Subject matter jurisdiction is conceptually easier. It just means that there are certain types of cases that can only be brought in certain courts. So, for example, divorces, and this is Georgia. In Georgia, divorces and adoptions can only be brought in Superior Court. The other courts, like a juvenile court, would not have jurisdiction over the subject matter of divorce or adoption. If you have an issue with a will, or you're filing a probate in a state, only the probate court has subject matter jurisdiction over that. So that would be something to keep in mind. Personal jurisdiction, remember we talked about that is really easy in the context of residents of this state. I live in Georgia. You can sue me in Georgia. I live here. The Georgia courts have jurisdiction over me. We talked a little bit about what happens if somebody who's not a resident of Georgia does something in Georgia. Could they be sued here even though they don't live here? Does a Georgia court have jurisdiction over a resident of another state? And we talked about how long-arm statutes give the courts in one state jurisdiction over the person of a resident of another state so long as the lawsuit has to do with the non-resident's conduct in this state. So, for example, let's say that Calhoun lives in Phoenix City, and after class this morning, he backs into my car. I'm a Georgia resident. He's an Alabama resident. Can I sue him in Georgia? Does Georgia have personal jurisdiction over him related to my truck lawsuit? Yeah, because his conduct in Georgia is the subject of my suit. If in Alabama he puts a sign out in front of his house that says something false about me, could I sue him for defamation in Georgia based on the sign in front of his Alabama house? No, the Georgia court wouldn't have jurisdiction over him for that because the conduct that I'm suing him over happened in Alabama. Personal jurisdiction over non-residents is achieved through the long-arm statutes. Corporations now are treated a little bit different. I don't think we got into corporations too much on Thursday. A corporation is subject to the jurisdiction of the place where it's incorporated, any place where it does business, and the place where it has its main office. So let's say that let's say that Circle K convenience stores are owned by a corporation, by the Circle K Corporation, And the Circle K Corporation is incorporated as an Illinois corporation. They have their main office in Birmingham, Alabama, and they do business. They have stores in South Carolina, Georgia, Alabama, and Florida. Where are all the places that the Circle K Corporation could be sued? What state courts have personal jurisdiction over the Circle K Corporation? The state where it's incorporated, so Illinois, they could be sued there. Even if they don't have any stores there or they don't have a headquarters there, they're incorporated under the laws of the state of Illinois, so they could be sued there. They could be sued in any of the states where they do business, so those 4 states I mentioned, and they could be sued in the state where they had their main office, which was Alabama. So corporations are treated a little bit different. These days, if you're doing business, or if a company is doing business on the internet or through the mail, and they're doing business from one state with customers in another state, that is going to open up that company to being sued in all those states where they do business. So let's say that, I know some of y'all said you're an entrepreneur. Who has a business already? Somebody in here had a business already. You do, LaPortia, you do. Do you have any customers outside of Georgia? Anybody have a business where they do any internet business? All right, well, we're going to expand LaPortia Enterprises, all right? Let's say that you own a string of waxing boutiques that it's in Alabama, Georgia, and Florida. You're subject to jurisdiction to be sued in those states because you do business there. That's similar to the example I just gave. Let me think about, let's say that LaPortia, you sell waxing supplies through your website, and you sell them to customers in every state in the union. And you send some wax to Hawaii, and your customer in Hawaii claims that there's something defective about it or caused some injury to her when she used it in Hawaii. Could you be sued in Hawaii over the wax that you sent out there? Absolutely. So any of you who own a business or are going to be doing any sort of business over the internet, just know that when you do business in another state, even if you've never set foot there, even if you don't have a physical business there, even if you're not headquartered there or incorporated there, you still could be subject to jurisdiction there. But again, remember, it would still have to be related to, the subject of the lawsuit would still have to be related to your conduct, your activity in that state. Doesn't mean that LaPortia's husband could sue her for divorce in Hawaii just because she does business in Hawaii. That's not how that would work. That has nothing to do with what she does in Hawaii. All right, that's the idea of jurisdiction that we just wanted to review. Venue. Venue is a little bit confusing because venue relates to, once you know what court system you're in, venue means which physical location of the court do you go to. So let me give you an example of that. Let's say that I live in Muskogee County and Calhoun lives in Alabama, and I backed into his truck this morning after class. He wants to sue me. He knows that he can sue me in Georgia because I'm a resident of Georgia and because the accident happened here. Which county in Georgia would he sue me in? That's venue. He knows he would go, let's say he would go to Superior Court, but which county's Superior Court would he go to? That's the idea of venue. Which physical location of the court do you go to? In order to bring a lawsuit, in order to sue somebody, you have to have what's called legal standing. So you've got to have an interest in the dispute somehow. Blaine could not sue me for divorce on behalf of my wife. He doesn't have standing to sue me. He's not part of that. We're not married. Taj could not sue me for backing into John's truck because that has nothing to do with him. He doesn't have standing to sue me on I, as a resident of Georgia, don't have standing to sue the state of Washington over one of their laws that I think is unconstitutional. If I don't have anything to do with that law, I haven't been subject to it. Let's say that states have been passing all these laws having to do with abortion rights since the Supreme Court decided the Dobbs case. And let's say that I don't like Texas's new abortion law. I can't go challenge Texas's abortion law. I don't live there. Um, also, I can't get pregnant. I have no standing. I don't have any interest in that law. Can't apply to me. I have no standing for that. There are some environmental groups that have tried to sue, like development companies or state governments who are building like pipelines and stuff on behalf of trees or the environment or something, and the courts have found that trees don't have standing to sue. They're not actual entities that are able to, even though they are affected obviously by building a pipeline, but they don't have standing to sue. So that's the idea on that. I want to take you through next sort of the steps in a lawsuit. So we're going to talk about litigation for a little while. Litigation is how cases move through the court system. It's the business of taking a case to court. Our whole system is predicated on the adversarial system of justice, and that means that before anybody can be found guilty of a crime or found liable in a civil case, they have the right to confront witnesses against them. They have the right to hear evidence against them. They have the right to, if you're charged with a crime or if you're sued in a civil case, you have the right to have the other person prove the case against you before you could be found guilty or liable. It's an adversarial system. So something can't happen without me, to me in a court, without me having the chance to speak up or challenge the evidence or question the witnesses, so on and so forth. That's how it works. The players in the system are this. So the person who files a lawsuit is the plaintiff. The person who the lawsuit is filed against is the defendant. I would submit it's much better to be a plaintiff than a defendant if you had the choice. But those are the players in it. In a civil case, which remember, civil laws settles disputes between people or people in corporations, does not involve crime. Remember, we said criminal law was this body of law that has to do with laws that the state has deemed socially unacceptable and so on and so forth. And then civil law is everything else. So in a civil case, the person who files the lawsuit is the plaintiff. The person the lawsuit is filed against the defendant. In a criminal case, who would the plaintiff be in a criminal case? Who brings the, somebody said it, the state, that's right. Or if it's a federal crime, the U.S. government. So let's say that when I backed into Calhoun's car this morning, that I was also hammered drunk. And the police came. Why are you nodding? Oh, okay. He's like, yeah. The police came and they arrested me for DUI. So in that situation, John can sue me in a civil case for damages for his truck and any damages that he's sustained physically or mentally. He would be the plaintiff, I'd be the defendant. In the DUI case, the state of Georgia would be the plaintiff and I would be the defendant. I've had 2 cases now going off of the same mishap, we'll call it, misunderstanding. Another difference between those court systems are my 2 cases. I think we talked about this last week, but I want to say it again because I want you to remember this. The burden of proof in the civil case is different than the burden of proof in the criminal case. Burden of proof meaning what the plaintiff has to prove in order for me to be found guilty of DUI or liable or responsible for the damage I did to Mr. Calhoun. The criminal case, the burden of proof is beyond a what? Reasonable doubt. Very good. Not beyond a shadow of a doubt, not beyond any doubt, beyond a reasonable doubt. The burden in the civil case is going to be, did we talk about this? By a preponderance of the evidence. And remember, that means more likely than not. 50.1% to 49.9%. So it could very well be that in my civil case with Calhoun over the damage I did to his truck, I could be found liable, responsible for that damage by a preponderance of the evidence, meaning more likely than not that I was at fault. I could be found not guilty in my DUI case because the state didn't prove that I was operating the motor vehicle while intoxicated beyond a reasonable doubt. I could also be found guilty. I could be found guilty and liable in both cases. But it is possible that I could be found liable, responsible in one, not guilty in the other, because those burdens of proof are different. Beyond a reasonable doubt is a lot higher than by a preponderance of the evidence. All right, everything that gets filed in a court case is called pleadings. That's the general collective name we have for everything that's filed. If I think about a lawsuit as a football game, then kickoff, the beginning of the game, what happens to start a court case is the filing of a complaint. The plaintiff files a complaint with the court, and the complaint sets out basically what their beef is with the defendant. Here's what happened. Here's the law that says that they're responsible. Here's what I'm asking for. Here's what happened to me. Here's what I'm asking the court to do. That's a complaint. Once the complaint is filed, then that complaint has to be served on the defendant, usually by a sheriff. Sometimes it can be by a private process server that's authorized by the court to serve process, but it's not enough just for the complaint to be filed. The defendant has to get personal service of the complaint. In Georgia, it means that they've actually got, if Calhoun sues me, files a complaint against me, the sheriff has to actually hand the complaint to me. He's got to give it to me. There's some, we're not getting into this, you're not tested on this, but there's some exceptions about whether or not you could give it to a person living at the home that the defendant lives at, and that gets a little fuzzy, but I do want you to be familiar with the idea that the defendant does or is entitled to service of process of the complaint. Then the defendant will turn around and file an answer to the complaint. So the complaint's going to be broken down into paragraph, fact by fact, usually have a different fact for each paragraph. And the defendant would then number his answer corresponding to the paragraphs in the complaint and either admit or deny each paragraph. Or you can say, I don't have enough information on which to either admit or deny. So what would that look like? So let's say that Calhoun's complaint against me says Mr. Tebow is a resident of the state of Georgia. In my answer, am I going to admit that or deny it? I'm probably going to admit that. There's no point in us spending time at trial establishing that I'm a resident of the state of Georgia. I am. I'm going to admit that part. If his complaint says Mr. Tebow negligently, recklessly, carelessly operated his vehicle in a way that backed into my truck, well, I'm going to deny that. Why would I deny that? Hard to prove that. Whose responsibility is it to prove that? The plaintiff's. That's right. You're exactly right. So I'm not going to admit that. If I admit that, then the trial's going to be really short, right? You don't have to prove it anymore. I admitted it. So it's not necessarily that I'm saying I didn't do it. I'm just saying that's something you're going to have to prove at court. Because remember, the plaintiff has the burden of proof, not the defendant. So I'm going to deny anything that Calhoun's going to have to come up with evidence to prove against me at our trial. After the complaint and the answer are filed, we're going. We're in the first quarter. Our football game's going. And we're going to spend the next 2 quarters really doing something called discovery. This is probably one of the most important, not the most important, one of the most important parts of any lawsuit. Discovery is the process by which each side, each party, gets to collect all the information that the other side has that's relevant to the case. So let's continue to use our car accident example. Let's say that in Calhoun's complaint, he has alleged that when I hit him, he suffered a broken leg, whiplash in the neck, and he suffered emotional trauma because it happened in front of his girlfriend, his good friend. The whole business school was watching. I don't know. He's alleged that. So in the discovery process, I want to find out everything he has that would be relevant to the case that he might use against me. How am I going to do that? Well, there are different mechanisms of discovery that I want you to be familiar with. One is depositions. Has anybody ever given a deposition? Nobody's given a deposition? Good. Deposition is when one of the parties has to sit down in front of a court reporter who's writing down everything that's said under oath and answer questions from the other lawyer. Depositions are not done in the courtroom. The judge or jury is not there. It is just private between the parties and the lawyers. But it's all recorded and written down, and it can be used in court. So that's one way that we would conduct discovery. My lawyer might try to take Calhoun's deposition, and at that deposition, my lawyer would ask, what would my lawyer ask John? What are some examples of what we would ask? What would you want to know, Ms. Vickers? You're my lawyer. John's alleged all these. What are some questions we're going to ask him? Trying to gather information. Yep. What all witnesses do you have? Who all's going to testify for you? What are they going to say? Do you have any pictures from the thing? Did you take any video? Did anybody take any video you have? What about Matt with his, you're also on my legal team. What about, he's alleged a broken leg, whiplash, and mental distress. What do you want to know about that from him? Yeah. Where'd you go to the hospital? Who'd you see? Did you go immediately? Did you go the next day? When did you go? Give me the names of all the doctors you've seen as a result of this. What have your medical bills been? Where'd you get your car fixed and what was the repair bill? I want to know all those things about it, and I can ask all that. That's one way to do it. Another way to gather information is through written interrogatories. That's a written set of questions that I send to John's lawyer, and then John has to give me written answers under oath to my questions. It's similar to a deposition. I'll be asking the same things. The advantage of a deposition over interrogatories is that I can then follow up with questions based on his answers at a deposition. I could do that through interrogatories, but that would require me writing them down, sending them over, getting them back, writing down follow-up questions. It'd be easier for me to say, what all hospitals did you go to? Then he's going to tell me, and then I can ask him from there. Tell me all the injuries you're claiming. Based on what he says, I can follow up from there. So deposition gives you a little bit more flexibility, I guess, in what you're asking. A lot of times we'll send interrogatories at the beginning of a case just to get us started. I might ask those basic questions at the beginning. List all the doctors you went to and what for and what dates you were seen. List the place where you took your truck. I might want to know that up front so that then I could begin requesting records from those doctors if I need to do it that way, or if I need to take the deposition of one of the doctors. I could do that. I might want to send interrogatories up front to go ahead and get me started. Sometimes I might send interrogatories, and that might be all I need. I don't really need to take his deposition. Depositions are a lot more expensive because we're paying the lawyers by the hour to do it, and we're paying the court reporter to take down all the testimony and evidence that's presented at the deposition, and then we're paying for the court reporter to type all that up and give it back to us in writing. So it can be expensive, and interrogatories could be a lot cheaper way to go about that. But those are two different methods of discovery that are very similar. Another discovery method that I want you to know about is a request for production of documents. Similar to interrogatories in that they're written. I send John's lawyer a list of things that I want him to produce to me. Bank statements, medical records, repair bills, things like anything, copies of any recordings that were made, any witness statements that he has, any written documents that he has that I think are relevant, then I'm going to request that he turn those over. And he's got to turn those over to me. Likewise, he can request whatever he wants from me, and I've got to turn them over to him, and I've got to answer his questions as well. One interesting thing about discovery that I want you to appreciate is just because, and this is going to sound a little bit contradictory to what I've been telling you this morning, you are required as a party to respond to discovery. So whatever he asks from me, I got to give him. But that doesn't mean that it can be used at trial. It's still got to be admissible as evidence in trial. It's still got to be relevant to the case. So he might ask me for some documents in discovery that I got to turn over to him, but it turns out that for one reason or another, they're not admissible at trial. Discovery is where we find out everything we need to find out about the other side. Doesn't mean it's automatically admissible in court. So that's the discovery process. I want you to put on your hats as an employee for a second. If you're working, put on your employee hat of whoever you work for. If you're not, I want you to just pretend. Let's say that you work for Aflac, big company, and there is a lawsuit. Let's say you're a manager and you have employees under you that you supervise, and one of them gets fired for the employee that's fired is over the age of 40, which, believe it or not, is protected by the Age Discrimination in Employment Act. Anybody over 40 is protected from being fired because they're old. And that employee, former employee, claims that he was fired for being old. What are some of the things that his lawyer might ask Aflac for in discovery? Or what kind of documents? Emails, performance reviews, emails. I want y'all to really think about that. Everything that you write or text that you've put down in a way that can be memorialized or saved, all of that is subject to discovery. So I'm not saying that you need to not ever, the lesson is not don't ever put anything in writing. The lesson is to be very careful about what you put in writing. Put the truth down. Don't put anything down that may look bad or come back to haunt you later on, because all of that could be subject to discovery. In one of the Trump cases, they conducted discovery. They sent discovery requests to Twitter for his DMs, and Twitter had to turn over Trump's DMs. So that's actually really scary. If you think about all your snaps and texts and Twitter DMs or Instagram, all those DMs you're sliding into. What if all that got discovered? Ruben's blushing. Or you got something to hide over here? Yeah, okay, you're not. No, that's not how you roll. Okay, good. Probably wise, right? So do think about that. Just be very careful what you put down. Any questions about discovery? Discovery, let me make one more point about that. It's not limited to, discovery is not limited to the parties to a case. I can send discovery requests in my lawsuit with Calhoun. I can send discovery requests to his doctors, send me his medical records. I could send a discovery request to Twitter, show me his DMs. I could send a discovery request to his cell phone carrier asking for his cell phone records. Certainly bank records, all things like that. So all that is subject to discovery. We're going to look at some real examples of pleadings on Thursday, and I'm going to scare all of you. I was about to say single people. I'm going to scare all of you married and single people because I'm going to show you some discovery requests in a divorce case and all of the things that a divorce lawyer would be asking for you to turn over in those type cases. So we're going to look at that on Thursday. At any point between the time that a case is filed and the case goes to trial, and even after trial in some instances, the lawyers can file motions with the court. Motions can be of just about any type. So there are certain motions that the law specifically spells out you can file. So for example, let's say that I sent discovery requests to Calhoun and he didn't answer my written interrogatory questions. I could file a motion with the court to compel him to answer my discovery, have the court force him to answer my discovery. That's something you'll find in the law. But you can also file motions for just about anything. Maybe I need a motion to change the time of a hearing because I've got a conflict. Maybe I need a motion I want John to undergo a psychiatric evaluation. I might make a motion to the court for him to have to get that done. He might make a motion to the court to have me drug tested. The reason we have to file motions is two reasons. One is a judge can't act on something that has not been brought before it. So a judge can't say, in this case of Calhoun versus Tebow, I'll see y'all Monday morning. I've got some things that I want to make y'all do. The judge can't do that. It's not been brought formally before the court. That's one reason we have motions. The other is that anything we do or ask the court to do, the other side gets a chance to respond to that. So if I file a motion to force him to answer my discovery, he gets the chance to file an answer to my motion explaining why he either thinks he did answer my discovery fully or why he shouldn't have to. That's motion practice. A couple of funny motions I couldn't find exactly the image I wanted to show y'all, but a couple of motions that have been filed in Georgia courts are that one prisoner who was litigating something filed a motion for the judge to kiss his ass. Motion to kiss my ass is what it was called. It was denied. And then there was a lady who filed a motion in her case is also in Georgia, and her motion was to F this court and everything it stands for. Also denied. I wouldn't advise anybody to file motions like that, but I couldn't find the actual ones. But those did happen. So that's motion practice. That takes us up to the trial. I think I told y'all last week, but if I didn't, I'm going to reiterate it. At trial, you could have a jury to decide the case. That's everybody's right. But you don't have to have a jury. If the parties want to just have the judge decide the case without a jury, that's fine. That's called a bench trial. And there are certain cases where it would be advantageous to have it one way or another. You have to both agree not to have a jury. If one side wants a jury, then you get a jury. If I'm suing, if I have a personal injury case or a products liability case or a medical malpractice case where a doctor has screwed up, I want a jury. I want citizens to come in that I can make emotional appeals to. I want them to, if I'm the plaintiff's lawyer, I want a jury. I want them to give me a big old award. If I represent the doctor in that medical malpractice case, I would much rather have a judge than a jury because the judge is a little bit less prone to emotional swings. The judges heard medical malpractice cases over and over. It's a little more desensitized to it. The judge has more of a business approach to it, as in, okay, if the doctor screwed up, let's compensate this person, but let's try to do it fairly. Whereas a jury, juries can sometimes just give huge awards. Juries are also very unpredictable. And so that's another reason that I might rather have a judge who's have a lot better idea of what that judge may or may not do. So you could have a jury trial or a bench trial. If you have a jury trial, you go through the process of voir dire. I don't think that's in your outline, so don't worry about remembering that, but that's just where you question the jurors. You want to know, if I have a medical malpractice case, I'm going to ask the pool of jurors, has anybody ever been injured by a doctor? Has anybody ever filed a medical malpractice case before? I don't want them on my jury if I'm the doctor's lawyer. I definitely would like to have them on my jury if I'm the plaintiff's lawyer. I might say, who all here is married to a doctor? I don't want that person on my jury if I'm the plaintiff, because that person, I would worry about that person being sympathetic to the doctor getting sued. So that's the process of picking a jury. Once the jury's picked, then you go on with trial, and this is the part that y'all know about, you're most familiar with, your opening statements, your questioning of witnesses, your closing statements, your lawyers making objections, your jury come back and giving a verdict, that kind of thing. You're familiar with that. Keep in mind, too, that at trial, because we have an adversarial system, any witness that testifies for one side has to answer questions from the other side's lawyer. You don't just get to go in and present all your witnesses and have them say what you want them to say, and then they get to sit back down. They got to answer to both sides' lawyers. That's called cross-examination. And then if once the verdict is in, then either side could appeal that if they wanted to. And we talked a lot about appeals last week and how that works. So I'm not going to dwell on that today, except for to remind you that on appeal, the appellate courts decide issues of law, remember, and trial courts decide issues of fact. So on appeal, there won't be a dispute about whether or not I backed into John. There would, if we're on appeal, the question would be about whether or not the law got applied correctly. Anybody have any question about litigation so far? All right, the second thing I want to cover today is this idea of alternative dispute resolution. So the vast majority of lawsuits, and I would say over 90%, get settled or resolved before they actually go to trial. Very few cases actually go to a full trial. Why is that? Well, most of them, it's possible for the sides to resolve the case themselves before they get all the way to a trial. And that benefits the parties if they can settle the case, because then, well, we'll talk about that when I finish about why this is all beneficial. Let me back up and just talk about the different kinds of alternative dispute resolution. That's what we call, that's the label for all these other ways that cases can get resolved without going to trial. One is negotiation. There is nothing that prohibits the lawyer from picking up the phone or writing a letter and making an offer to the other side. Calhoun sues me. There is nothing that keeps my lawyer from picking up the phone and saying he'll pay $50,000. They can accept that. They can make a counter offer. They could tell me to go jump in the lake. I can negotiate and make offers, and they can accept offers all the way up to trial. Sometimes we actually go to trial, and based on the way it's going, one party might say, hey, judge, time out. Hey, let's go talk in the hall. I got an offer to make you. That happens all the time, especially in criminal trials. You'll see where they'll enter a plea agreement based on the way the trial is going. It might be going so good for one side that they're like, too bad. Let's just see what the judge or the jury says. But you can make an offer and settle a case in the middle of the trial. There's nothing wrong with that. That's just straight up negotiation. Negotiation can happen before the lawsuit is even filed. I'll give you an example. I had an intern work for me this summer who is a student at Georgia Law, and his dad had a dispute with Neal Brothers Tire. So I let the law student write a letter to Neal Brothers Tire demanding like it was like $1,000. It was small beans. And I signed it for him, and we said, we're asking for $1,000. Here's what happened. And if, we'd like to work this out without going to court, but if we can't, then we'll file a lawsuit. And Neal Brothers called back and said they'd pay him $1,000. So that got resolved without even becoming a lawsuit. That's just an example of private negotiation. A different way, another way of alternative dispute resolution is mediation. Mediation has gotten so popular over the last 20 or 30 years that all civil cases, not criminal cases, but all civil cases are required to go to mediation before you can go to trial. You got to try to mediate your case before you can even go to trial. It's like getting your golden ticket to Hollywood on American Idol. Can't go to trial without your ticket. The reason mediation is required and it's so popular is because it works in a majority of cases. Mediation works like this. You got a neutral mediator, who's not a judge, not affiliated formally with the court. The mediator has got to be licensed by the state of Georgia, but it's not too terribly a hard thing to do, is to become a mediator. And the parties show up at any location. It could be one of the lawyer's offices. It could be, it could be in a hotel conference room. Could be in the parking lot, in theory, but nobody really would mediate in the parking lot. You show up, parties come together, the mediator explains the rules of mediation, how all this works. The mediator says, tell me what kind of case this is, because the mediator, remember, is coming in. The mediator is objective and neutral. We don't want the mediator to have talked to anybody beforehand. We want them to be completely fresh. Tell me what kind of case this is. We sit down. Okay, Mr. Mediator, Miss Mediator, this is a car wreck case. We contend that Mr. Tebow, this is John's lawyer talking, we contend that Mr. Tebow backed into him. He is looking for damages for his truck. He's looking for damages for medical injuries, so on and so forth. That's what this case is about. Parties split up, go to separate rooms. The mediator goes back and forth trying to see if there is some middle ground that the parties could agree on, settle the case. He might go to John first as the plaintiff and say, what are you asking for? John says, I want $500,000 for this, 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 and this. Mediator comes to my room, says they're asking for $500,000. Do y'all want to make a counteroffer? We say, sure, we'll offer him $500. We're pretty far apart there. But the mediator would then at that point keep going back and forth and try to see if there was some middle ground that the case could get settled on. In a money case, I mean, it's much easier to zero in on how this case is going to get settled, right? Calhoun wants to get paid, and I'm going to have to pay him. I mean, that's really the main issue, is how much. Think about a divorce case for a second with children involved, minor children involved. We got to talk about custody of the kids. We got to talk about alimony. We got to talk about child support. We got to talk about dividing up all the assets of the parties. We got to talk about how we're going to handle Christmas vacation and summer vacation, and who's going to buy a car at 16, and so on and so forth. So there's a lot of back and forth going on there. My example on the car wreck is sort of, all right, let's just see if we can keep getting closer to the middle on the number. In something like a divorce, we might say, okay, we've settled on custody, but we're here on child support. wife wants 50% of the retirement account and she wants the house. The mediator has a lot more to work with there. The mediator could be like, okay, well, what if he gets the house, but you get all of the retirement account? There's just a lot of different ways to kind of negotiate that out. That's a civil case. That's not business law, but I just offer that to you as a kind of a good example of how mediation works. You're not required to settle at mediation. You're not even required to stay there more than 5 minutes if you don't want to. Most people will stay there as long as it's beneficial to them. And then at some point, you'll come to an impasse or you'll settle the case. You settle it, that's great, you're done. You don't have to keep paying your lawyers and you don't have to keep waiting on a court date into infinity. You can get your case done right then. So that is certainly a benefit of it. Mediators, as I said, are neutral. They don't make decisions. They don't. If you can't come to an agreement by the end of the mediation, then it's just over. The mediator doesn't at that point say, "Okay, here's the deal. This is what's going to happen." Mediator has no power to do that. Another important feature of mediation is that everything that happens at mediation is confidential. So, Mr. Sharp, put on your lawyer hat for a second. Put on your party hat for a second. Let's say that you are the plaintiff in the car wreck case. Why would you want everything that's said at mediation to not be repeated in the courtroom or told to the judge? Why would you want that to be confidential? It's okay if nothing comes to mind. Taj, what do you think? Why do you want mediation to be confidential? Say that again? Not sure yet? All right. Who's next? You were looking at me, but then you looked away. That's smart. Luke, I'm sorry, I'll come back to you. That's right. Do you want the judge to know that, or the jury to know that Calhoun wanted $500,000? Not if he goes to trial and tells them he wants $1 million. Then my lawyer's going to stand up and say, "Well, at mediation, you said you would take $500,000. So now your greedy ass is in here asking for $1 million? You don't want that said." Likewise, I don't want them to come in and say, "Ladies and gentlemen of the jury, Mr. Tebow was willing to pay $500 to settle this case. $500. And Mr. Calhoun's in there in his, body cast, right? Look what he's done. He's willing to pay $500. So we don't want that. If I'm the mediator in the case, then I want people to tell me why they are offering what they're offering. What's the rationale behind why you're asking for that? If somebody's worried about that being used against them in court, they're not going to be candid with the mediator. They're not going to share that information. So everything that happens at mediation is confidential for all those reasons. The next alternative dispute resolution that I want you to be familiar with is arbitration. Arbitration is like an informal trial. The arbitrator, unlike mediation, the arbitrator does make a decision. You end up at arbitration with, they call it an award, but you end up with a decision. Whether you like it or not, you didn't agree to it. You're just putting on your case before an arbitrator. You can call witnesses, you can produce documentary evidence, you can make arguments, you make objections, kind of like a mini trial. And that arbitrator will make a decision at the end that's binding on the party. That's your trial. That's your day in court. Why would, I'll give you another chance. Why would, because I interrupted you, I'm sorry, just because he raised his hand. Why might you want to go to arbitration instead of going to trial? And I recognize y'all aren't lawyers, so it's okay if you don't know. No jury, very good. I might rather have that arbitrator than risk the jury. What are other reasons? What do y'all hear as an advantage of arbitration? Yes. Very much so, less drawn out. that lawsuit could get filed and we could be like, you know what? Let's get it go to arbitration. It may be 18 months, 2 years, could be 3. It wouldn't be uncommon for a long drawn out medical malpractice case or something to go 3 years before you even get to trial. Yeah, let's get it over with. I want my money now. Let's just, whatever's going to happen is going to happen. Let's do it. Very much so. We also might have a really specific subject matter of our dispute that we want to pick an arbitrator who's skilled and has knowledge in that area. Let's say that Columbus State hires a contractor to build a new building and they have a dispute that arises out of their construction contract. Then they might much rather pick a lawyer who has spent 40 years practicing construction litigation to be their arbitrator rather than, let's say, a brand new judge who did criminal law as a lawyer before she became a judge. That criminal lawyer doesn't know anything about construction litigation. I'd much rather have the expert decide it. So that might be another reason you would pick arbitration. When you guys sign contracts, leases sometimes with lots of consumer type contracts, they have arbitration clauses in them that say that y'all are agreeing up front that if you have a dispute that's related to that contract, you're going to go to arbitration. If you agree to that, then you have to go to arbitration. You can't go to court. You've agreed to skip the court process. That might be good for you, but you just need to be aware of that if you sign those agreements, you're locking yourself into arbitration and you're locking yourself out of court. And again, it might be a good thing. Bigger businesses tend to try to put the arbitration clauses in contracts because they would much rather have quicker cases and cheaper processes than let's say Target. I don't know what agreements you might have with Target, but maybe your Target card agreement or something. They don't want to have 3,000 different cases going on in 3,000 different courts across the country. That's just time consuming and expensive for them. They would rather go to arbitration. They might also rather go to arbitration because the result of an arbitration could be private. So if I'm Target and I'm doing something wrong and we're going to arbitration, I'd much rather have the result be confidential than have everybody know about it. That might be another benefit to Target of going to arbitration. Not all arbitrations are private, but a lot of them are. Are confidential, but a lot of them are. So, to sum up for a second, the advantages of using any of the alternative dispute resolution techniques are: you get your case solved faster, which means less expense, less waiting. You would have, with negotiation and mediation, not with arbitration, but with negotiation and mediation, who's got control over the outcome? The parties do. You don't have to agree to anything, right? But if you agree to something, it's because you're voluntarily agreeing to it. You've got control over the outcome. If you go to arbitration or you go to court, who's got control over the outcome? The arbitrator or the judge or the jury. It's out of your control. I mediate divorce cases still a lot, even though I don't practice that anymore. And I will tell the people, you've got this deal in front of you that they've proposed. You can take it, and you might not like all of it, but you're going to like some of it, and you've got control over it. For example, y'all have agreed upon how you're going to do visitation with your children. It's much better for the two people who are going to have to actually live it to make that decision than to go have the judge decide it. You go to court, the judge is going to tell you how your visitation schedule is going to go with your children. He or she might listen to what you want, but at the end, the judge is going to tell you how to do it. And every other weekend or however you do it, you're going to be picking up and dropping off your kids according to a schedule that the judge told you had to do, rather than one that y'all agreed to yourself. Now, there are in divorce cases, certainly, we can't agree. There are certain times you can't agree and you just don't have any choice but let the judge decide. But it is much more advantageous, I think, especially in family law cases, to go to mediation or negotiate it and have some control over it yourself, if you can. Not always possible, but if you can. So those are the advantages of alternative dispute resolution. Thursday, I've assigned you some reading to do for Thursday, but it's not long. So Thursday is going to be a complete class of nothing but discussion. And we're going to talk about, I'm going to give you an example of a complaint, an example of some discovery, and then we're going to talk about all the Trump litigation. Now, we're talking about the Trump litigation. I want to make sure I'm clear on this so y'all understand. We're talking about it for a couple reasons. One, I think it would be foolish of me to teach a law class and not incorporate some of the most famous litigation our country has ever had. And we're talking about it because it's a very good illustration of the stuff we've been talking about for the last 2 weeks. I'm talking about those cases from a legal perspective. We are not going to talk about those cases from a political perspective. Just so you know, I am apolitical. I hate politics. I don't teach a political class. This is a law class. So I don't want anybody to feel uncomfortable that this is getting ready to turn into a riot, a political riot or something like that. We're just not getting into that. But the legal aspects of what's going on with Trump are fascinating to me. And I think they're very much current and applicable to what we're talking about. So we're going to go through all that. There's a Politico article that I've linked for you in the content module. What I like about this article is it tells you what he's charged with, and you can click on that, on the charge, and it'll take you directly to the law that he's alleged to have violated. So like in the Georgia case where it says he's been charged with conspiracy, you can click on conspiracy and it'll bring up the Georgia conspiracy statute. It's a short statute. So if you're interested, you can jump back and forth on that. So we're going to talk about the criminal cases, and then I've given you a very, very short article to read on the civil case that Trump has going on right now. It was a defamation case with the author, Jean Carroll. He went to trial in April on that, but then she's turned around and sued him. She sued him for defamation for some false things he said about her. And then after the jury came back and awarded her, or came back and found for her, he said some additional things. So she amended her complaint, and they're going to go back to trial in January on the new things that he's said bad about her. So I want to talk about the criminal aspects of all that, the civil aspects of all that, the ideas of discovery, what evidence might be presented at trial, kind of how all that looks for him. So that's what we're going to do on Thursday. Keep in mind now, you've taken one of my quizzes, so you kind of know where I'm headed on this. After class on Thursday, I'll finish writing the quiz, and it's going to have to do with stuff we talk about in class on Thursday. So if you can't come to class for some reason, we'll definitely watch the video because there will be lots of content that I'm going to test you on based on what we discuss and what you've been assigned to read. So I will see you all Thursday.